Hi again, Attorney Steve Vondran. We are talking civil litigation. We are talking what is a demur, the legal definition of demur, and what do you do when you file a complaint and somebody else files a demur, or somebody files a complaint against you and you are deciding whether you should file a demur. So this video is going to talk about the concept of demur under California law. Let's go without further ado to the Attorney Steve whiteboard, litigation whiteboard. Okay, so we're talking about demurs. What are they? A demur, basically what happens is one party's going to file a complaint. That's you, that's them. Somebody's going to be setting forth their facts, their grounds for relief, what they felt was done wrong to them. You're going to name all your different causes of action. You may be naming fraud. You may have breach of fiduciary duty, you may have breach of contract, you may have intentional infliction of emotional distress, you may have all kinds of claims in your complaint. Now, it's the plaintiff's job to name the causes of action that they want to put in the complaint and to sufficiently plead the elements of each cause of action. For example, in a case for fraud, like let's say real estate fraud, you have certain elements that you must plead. A false statement of fact, a present fact, a material fact made to induce a plaintiff to rely on that fact. No knowledge that the fact was not true when it was stated. Reliance on the fact, damages. So you have to allege these specific causes of action specifically. If you're not coming forward with laying out the proper grounds for your cause of action, the other party may file a demur. Okay, and so demur is just a fancy word to say they're going to challenge the sufficiency of your pleading. They're going to be coming to the court and saying, basically, even if everything the plaintiff is saying is true, they don't state a cause of action for the following reasons. It's not specific. It's exceeded the statute of limitations. The plaintiff can't sue because they're a minor. Different types of things to challenge the sufficiency of the pleading. Now, they're not all challenging the factual basis of your pleadings, like did this happen, red light, green light. They're not challenging that. They're challenging the way that you pled the complaint. They're challenging some defect in the way that you went about putting together the complaint. So in some cases, a grounds for demur may apply. Sometimes you'll see a demur filed also with a motion to strike, and that's basically cutting out different parts of your pleading, so you often see those going hand in hand, a demur and a motion to strike. But let's talk a little bit more about it. So you filed the complaint, and the defendant in California has 30 days to respond. So one of the ways that a defendant could respond is by filing an answer, basically saying, I deny, 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 deny. Okay, but one of the other options for a defendant in a California lawsuit is to file the demur. Okay, the demur is just like the answer, needs to be filed within 30 days. Okay, that's why we have this within 30 days. Okay, sometimes the attorney for the defendant will come forward and say, can I get an extension of time? It's up to you if you want to give extensions of time. 30 days is the time frame to respond to a complaint. Now, the demur is testing the legal sufficiency of the pleadings. So it could be a particular cause of action that's being challenged. You could have 10 causes of action and the plaintiff is trying to get rid of one or two of them. Maybe they're trying to get rid of fraud because that has punitive damages. Maybe they say that you don't have enough information to plead fraud, and so you cannot plead it. So that may be something that you see. You have 30 days. Again, the court will assume the truth of a plaintiff's pleadings. This is very important to note that a plaintiff gets to make their pleadings. They don't have to have all the proof at the beginning of a lawsuit, but you have to have the good faith allegations, and the court is required to take those pleadings in the light most favorable to the plaintiff, to assume the truth of the allegations. So it's not really questioning the facts, it's questioning how the plaintiff put their complaint together. That's what a demur is. Okay? Court will assume the truth of the plaintiff's allegations. What are the grounds for a demur? We have this in CCP 430.10. CCP stands for Code of Civil Procedure. If you got that right, pat yourself on the back, give yourself 10 points and a star. CCP 430.10 gives you the grounds for filing a demur. There's lots of different types of grounds. I'm going to go over the main ones here. You have statute of limitations problems. If you have somebody that's filing a complaint saying 15 years ago there was a breach of contract, well, there's a statute of limitations on that in California. It depends whether it was oral or written, but a statute of limitations may be your grounds for filing a demur. You may have a complaint that is pulled off the internet, it's cut and pasted, and you're going, what on earth is this person alleging? I do not understand this. Ambiguity, uncertainty, that's another common ground for a demur. Now again, that could be toward the complaint in general, or it could be just to a specific cause of action. Another ground, failure. This is the one you see all the time. Failure to state a claim upon which relief can be granted. Failure to state a cause of action. Okay, what does that mean? That means you're not pleading all the elements. Even if everything you said is true, you don't plead the proper elements to make your claim. This is why it's important for plaintiffs in litigation and defendants to take a look at this. The jury instructions. You can find them out there on the internet. Pull up the jury instructions for fraud. Pull up the jury instructions for financial elder abuse. Pull up the jury instructions for intentional infliction of emotional distress. And when you're pleading your case, make sure you have all those elements met. Okay, if you have all those elements met and you're explaining the facts as it applies to the law, it's going to be tough to file a demur against you. They may win on motion for summary judgment, that's another story, but you'll have proper grounds if you're alleging all the facts that you need to allege and the elements of each cause of action, okay? So if you don't, failure to state a claim is something you could possibly see. Another common ground is capacity. Maybe it's a minor suing and you say, a minor kid's 8 years old, he can't file a lawsuit. Could get a demur on this. Improper joinder of parties is another one that you'll see. So capacity. And every now and then you'll see one, what we call a general demur, challenging the subject matter jurisdiction, the jurisdiction of the court to hear it. So you may have a general demur. Otherwise, what you usually have is a specific demur to the complaint or to particular causes of action. So you have your complaint, your demur. Your demur is going to set forth your points and authorities. This is the critical piece. This is why you may need to get a lawyer involved. You need to set down your law as to why the plaintiff isn't pleading the proper elements. So you need to set down your law. Okay, points and authorities. That's very important. You will find the code section here for demurs. CCP 430.50. There's a good code section for you to look up. Another thing is when you're filing your points and authorities, your demur, you may also get typically a request for judicial notice. We've done other videos and blogs on what a request for judicial notice is, but that's basically asking the court to take notice of certain facts that are beyond dispute. And so we'll go into that in another video, but you may also be filing these together. As I mentioned, you may also be filing a motion to strike, MTS we call that, a motion to strike, okay? So this is it. You want to be careful when you're looking at filing motions that you're complying with CCP 1005 in regards to your timing requirements, setting the hearing out in advance so that the other party has an opportunity to oppose, okay? Google CCP 1005. I've got a nice video out on that, so that'll tell you a little bit more about your timing requirements. Again, your defendants, your plaintiff is going to be able to oppose your demur, and you're going to be able to reply. The plaintiff has the final say, and then it goes to a hearing. So it's a very simple process. This is a basic overview. Now, if you're the plaintiff and you say, well, what happens if I don't get everything in there? You seek leave to amend. You tell the court in your opposition, fine, I may not have pled everything, I need an opportunity to amend. Okay, one other key tip is do not submit evidence of your case and everything, because you may end up finding that the other party wants to convert your demur into a motion for summary judgment, or your opposition to convert that into a motion for summary judgment. In most cases, plaintiffs aren't ready to do that just yet. So be careful of submitting too much evidence. This is Attorney Steve Vondran. If you like what you see, if you need some help with civil or litigation in state or federal court, business, real estate, intellectual property disputes, give us a call, click here to subscribe. We look happy to talk to you.